So not taking good care of my health lately, but that's another story for another day. Greetings to everyone from across the province, from Chief Justice Strathy, Associate Chief Justice Morocco, and the members of the Civil Case Management Pilot Project Committee, chaired by Justice McEwen and Scott Maidment. I was a member of that committee. I'm very happy to discuss with you a new pilot project, which will be rolling out come February of next year, in enhanced case management. So what you say is enhanced case management. Let me tell you about it with a little bit of background first. The project comes out of a recommendation from the American College of Trial Lawyers, who wrote a paper called Working Smarter but Not Harder in Canada, which seems like a very, very good idea. And it is recommendations about changing the case management process in Canada, and in Ontario in particular we're dealing with, to make it work better, to make cases move more quickly. We all know that the biggest problems with civil litigation in Ontario is the excessive cost and the delay. So Justice Strathy said, we need to start thinking outside the box. There's got to be ways to improve the system and make it work better. We need to think about new ways of doing things. So from that was born the committee, and from that has come recommendations for the pilot project, which when it boils down, comes down to this. There is going to be appointed in every region across the province at least one judge, and in Toronto possibly 2 or 3, also possibly 2 or 3 in the Ottawa region. Judges who are particularly keen on case management and have the ability to effectively case manage cases in the way that's being anticipated by this program. The judges who are going to do this case management will case manage the case from the point that they're appointed through to the end of trial, not just up to trial. They will not be involved in settlement conferences or a pre-trial where confidential information might be exchanged that you wouldn't want your trial judge to know. But your case management judge will be the judge that hears your case. Under the current rules and legislation, obviously people can't be pushed into this kind of a situation because our rules don't allow for the case management judge to also hear the case. So it's going to be for the pilot project period of 2 years. It'll be on a consent basis. It's meant to be for the more challenging cases that are complex factually or legally, med-mal cases, cases where there are you need a lot more hands-on from the supervising judge. So there's going to be just lost my train of thought. There's going to be a practice direction that will be coming out. They're just fine-tuning it literally as we speak, so it should be coming out in short order, which will explain all of the steps in the process, how you can request for your case to be put into this project, how the judges will then deal with the issues throughout the case. But the guts of it is that once you have a case management judge appointed, You'll have a very early meeting with the judge. You'll talk about the key issues in the case, try to identify what the main facts are that you're going to need to be dealing with, the issues you think are going to arise. The judge will, in most cases, if it's possible, set an early trial date, and basically you work back from the trial date so that the case is going to get to a trial on a timely basis. Interlocutory motions will be discouraged. The intent is that the case management judge will deal with most interlocutory matters on an informal basis through case management meetings, which can take place by email, by telephone, and in person if necessary. But you will only be allowed to have interlocutory motions with leave of the case management judge. And obviously the intent is that, excuse me, that most things will be resolved in a more informal manner. It's meant to encourage consensual resolutions with the hopes that people will act a little more reasonably in the processing of their cases if they know that the judge who's hearing the interlocutory matters is also going to be the judge hearing the case at the end of the day. It will assist with moving the cases forward so that you can address substantive issues in a more focused manner. And at the bottom of it all, in keeping with the themes that we've been hearing over the course of the last day and a half, it's meant to encourage collegiality and cooperation between the members of the bar through this process. So like I said, the project's meant to roll out come February. The pilot project will last for 2 years, at which point it will be assessed to see if it's working, if it needs tweaking, and whether it should be extended for a longer period, or whether, if it's working, whether there should be recommendations for changes to the rules to allow for this on a broader based rollout across the province. So that, in a nutshell, is what enhanced case management is, and coming to a court near you. If there's any questions, I can happily take those. We spend a lot of time with the committee reviewing the process, what's happening in the United States, whether rule requirement changes were necessary, answer yes, and worked out the draft of the practice management protocol, which now the judges are fine-tuning so that it meets with their approval as well. So happy to take questions if anybody has any thoughts or issues about what's coming down the pipe.
Thank you. Nicola Edmondson, Lanark. You mentioned one judge. I think you said per region, is
per
that
region.
correct?
So there'll be one for each of the 8 regions, multiple for Ottawa and Toronto.
Okay, so if you're in a smaller center within the larger region, would then the Ottawa ones, for example, be coming out to Perth and Brockville?
Well, I'm not sure about the logistics of how that would work. I don't know that they will be traveling judges in the different regions. I'm not sure how that part of it will work. If you want a judge in the region to be appointed, the plan is that you'll make a request to the RSJ in your region, who will then appoint somebody. And the vast majority of the case management won't need to be done in person. It will be done over the phone, by email, or whatever kind of conferencing you need, rather than the in-person. So you don't need to have, if you're in Cochrane and your case management judge is in Sudbury, you can still manage most of the case conferencing remotely rather than having people have to travel.
And is there any intention for this to apply to family law cases? I'm thinking of high conflict custody access.
Not yet. We're starting it with the civil, see how that works, and then, once the 2-year period is over, we'll look to see whether it makes sense to roll it into other practice areas as well.
Thank you.
You're welcome. Anybody else? So Justice, if there's no other questions, Justice Strathy and the committee are asking you to take the message back to your memberships to let them know that this is coming. We really want to encourage participation in the program, especially for the big complex cases, the high conflict cases, and the ones that really need more shepherding to make through to a reasonable trial date. And we'd really like to see participation across the province for the program. Thank you.